The law says 28 days. The judge says whenever. This is my personal reflection on the July 2026 Hannity segment about the prolonged preliminary hearing process in the prosecution of the man accused of assassinating Charlie Kirk. The FOX participants were openly critical. They called the delay absurd, outrageous, shameful, and destructive of public confidence. One legal analyst, drawing on 46 years of experience, said he had never seen a preliminary hearing handled this way. He compared it with the O.J. Simpson case, where the preliminary hearing occurred about 30 days after arrest and the trial began roughly 5 months later. In the Kirk case, nearly a year had passed without the defendant even entering a plea. FOX identified a serious problem. In my opinion, however, the discussion stopped just before reaching the conclusion that mattered most. The comfortable explanation. The panel treated the situation largely as the failure of one inexperienced judge. Judge Tony Graff had reportedly been on the bench only 4 months when assigned the case. The suggestion was that he was afraid of making a mistake and therefore agonized over every procedural step. That explanation is comforting because it preserves faith in the system. The law remains sound. The problem is simply that a novice judge has not yet learned how to apply it. But that may avoid the deeper issue. The judge can proceed this way because procedural law, no matter how firmly written, often lacks an automatic mechanism compelling judicial obedience. The law may establish a deadline, but the judge controls the calendar, decides whether good cause exists, determines whether additional briefing is necessary, and ultimately decides whether departure from the rule is justified. The 28-day rule. Utah criminal procedure provides that when a preliminary hearing is not waived, it should occur within a reasonable time, generally no later than 14 days after the request for a defendant in custody and 28 days for a defendant not in custody. The rule is written in the language of a deadline, not a suggestion. But what happens when the deadline passes? Does an independent authority immediately intervene? Does the judge personally face a consequence? Does the victim's family receive an enforceable remedy? Is the case automatically reassigned? Does the written law somehow place the proceeding back on schedule? Usually, none of those things happens automatically. Instead, the same judicial institution responsible for administering the deadline decides whether the delay was permissible. Judges evaluate the conduct of judges through standards such as reasonable, necessary, good cause, fairness, and discretion. The deadline remains visible on paper, but its practical meaning depends on the person wearing the robe. What FOX did not ask. The participants strongly criticized the delay. They spoke about the rights of Charlie Kirk's family, the apparent strength of the evidence, the danger of allowing delay to become a defense strategy, and the damage to public confidence. Yet no one fully challenged the assumption that the judge possessed the practical authority to manage the case in this manner. They said the judge was wrong, but they did not ask what wrong means when no immediate institution can compel correction. They said he lacked confidence and experience, but they did not ask whether a more experienced judge would obey the written rule, or simply be more skilled at explaining why the rule did not control. They criticized the exercise of discretion while leaving the supremacy of discretion untouched. Reports also indicated that both sides wanted the transcript and an opportunity to submit briefs before the judge ruled. That complicates any claim that the delay was created by the judge alone. But it reinforces the structural question. If the lawyers and the judge can collectively transform a supposedly prompt probable cause proceeding into a year-long process, what practical protection does the deadline provide? A rule that can be indefinitely accommodated may become a recommendation written in mandatory language. Public confidence without public power. The FOX analyst said the delay undermined public confidence. That is true, but the phrase public confidence is often used as though judges depend on it the way elected officials depend on votes or businesses depend on customers. They generally do not. The public may become angry. Families may suffer. Commentators may complain. Yet the judge continues controlling the courtroom unless another legally empowered institution intervenes. A judge may be criticized for delay and continue delaying. A court may be accused of ignoring a rule and still remain the institution authorized to interpret that rule. In practical terms, judges may have little institutional reason to care whether the ordinary citizen considers a particular proceeding fair. The meaningful questions are usually whether a higher court will reverse the ruling, whether a disciplinary body will act, and whether the judge can formulate an acceptable explanation. When appellate review is slow and deferential, and discipline authorities dismiss complaints as legal error, public confidence becomes ceremonial language rather than a practical restraint. The parallel with Paul Kessler. The prosecution arising from Paul Kessler's death presents a troubling parallel, even though the cases, charges, jurisdictions, and procedural stages are different. Kessler died after being struck during a politically charged confrontation and falling onto the pavement. The case continued for more than 2.5 years. It ended not with a public jury trial but with a guilty plea and a judicial sentence of 1 year in county jail and probation, despite prosecutors seeking state prison. The comparison is not that the Kirk and Kessler cases are legally identical. The comparison lies in the distance between the public's expectation of law and the institutional reality of judicial control. In both cases, a death occurred in an intensely political setting. In both, the public expected a transparent and timely process. In both, legal professionals controlled procedures that ordinary citizens could observe but could not direct. The Kessler case showed how years of investigation, negotiation, hearings, and discretion could produce a result far removed from what many members of the public expected after a violent death. The Kirk proceeding raises the related question at an earlier stage. How can a probable cause determination consume nearly a year when the procedural structure speaks in terms of days? The real enforcement problem. The problem is not that judges are treated as intellectually infallible. The problem is that there is often no effective mechanism for declaring that a judge violated written law and compelling an immediate correction. Appeals are expensive, slow, deferential, and often unavailable until the procedural damage has already contaminated the case. They are not a realistic remedy for every ignored deadline, distorted procedure, improper evidentiary ruling, or discretionary obstruction during an active proceeding. Judicial discipline systems rarely determine whether the law was correctly applied. They often classify the complaint as legal error unless the conduct fits some separate and vaguely defined category of misconduct. Conflicting judicial interpretations do not solve the problem. If several judges depart from the written rule in different ways, multiple interpretations do not prove that the rule of law is functioning. They may simply demonstrate that each judge can substitute an individual version of law for the text enacted to govern everyone. The decisive question is whether any institution is willing and able to say that the written law was violated, restore the procedure, and impose consequences before the violation becomes the permanent reality of the case. 2 new rules. Perhaps honesty requires 2 additional rules at the beginning of every procedural code. Rule 1. The judge is always right. Rule 2. If the judge is wrong, refer to Rule 1. The statement is sarcastic, but the institutional problem is serious. Inside a live case, the judge's interpretation has immediate force while the written rule has only potential force. The litigant must obey first and challenge later. The family must endure the delay first and complain later. The public must accept the postponed decision, excluded evidence, closed exhibit, or unexpected sentence first and perhaps learn years later whether another court considered it improper. That does not establish that the judge was legally correct. It means judicial power acts immediately, while accountability often arrives late, weakly, or not at all. The questions Fox should have asked. The segment should not have stopped at asking why this particular judge delayed the Kirk case. It should have asked, what is the value of a 28-day rule if the process can take nearly a year? Who has the authority and duty to enforce that rule against the judge administering the case? What remedy belongs to the victim's family when the deadline is disregarded? And most importantly, is the judge under the law? Or does the law acquire practical meaning only after the judge decides how much of it to honor? Conclusion. The FOX participants correctly recognized that something was deeply wrong. They described the symptoms: delay, uncertainty, excessive accommodation, secrecy concerns, and declining public confidence. But they stopped before naming the institutional disease. The problem is not merely that one inexperienced judge may make a poor decision. The problem is that American procedure often gives judges enough discretionary space to disregard the apparent command of a written rule while continuing to act in the name of that same rule. The public is then asked to preserve confidence in the system, not because the law was demonstrably followed, but because a judge remained in charge. That is not rule of law in its strongest meaning. It is rule through judicial permission. Until the media, lawmakers, and public are willing to confront that distinction, statute books may continue promising deadlines, rights, transparency, and prompt justice while the courtroom follows a different rule. The proceeding will move when the judge decides that it will move.